Tuesday, March 2nd at 2:05 p.m. in conference room 325. First on the agenda, we have HB 1032 relating to the Uniform Controlled Substances Act. First up, testifying, we have PSD in support.
Good afternoon, Chair. Jared Redula, the State Narcotics Administrator. With respect to this bill, I want to point out two important parts of our testimony. First, this bill proposes to make permanent the temporary changes to law that PSD had made during 2020. They include adding to our drug schedules in alignment with what the federal government has done, as well as two emergency scheduling of controlled substances, which I ordered in order to avoid an imminent threat to the community's safety. Second, I want to point out that this bill proposes to deschedule certain approved cannabidiol drugs, specifically the drug Epidiolex. And what we anticipate by the descheduling is that that drug, which is derived from cannabis, will we probably will broaden access to that important drug, which is used to treat seizures in children. Chair, we really need a bill like this one passed. There are other vehicles in the legislature, HB 324 and SB 1333, which proposes to make changes to Epidiolex only. We need a bill like this one, which is more comprehensive of the other drugs, to ensure that law enforcement and regulators in the government can handle these drugs when they appear in our community. Thank you very much.
Okay, thank you. Next up, we have the Akamai Cannabis Clinic in support. Oh, and sorry, everyone. There's a 2-minute limit on testifying, but we'll give you a warning before that's up. So Akamai Cannabis Clinic in support.
Yes, good afternoon. Aloha, Chair, Vice Chair, members of the committee. For the opportunity to testify on this measure. My name is Dr. Clifton Otto, and I am a cannabinoid medicine specialist in Hawaii. I stand on my written testimony, but I just wanted to very briefly highlight a change to this measure that I am proposing. Now, this bill is an excellent example of how important it is to maintain consistency between the state and federal regulation of controlled substances, something that the state authorized use of cannabis in Hawaii has not been able to enjoy for over 20 years. Unfortunately, the current conflict with the federal regulation of marijuana is encouraging criminal activity to spread throughout our medical cannabis program and across the state. I believe there is a solution for this conflict that I'm proposing in as amendment to this bill. If the committee feels that this issue needs to be addressed, but would create a substantive change, then I respectfully request that the chair consider delaying decision-making on this measure so that an HD1 can be proposed and a public hearing reconvened. Thank you for taking the time to consider my testimony on this important issue, and I will be available for questions.
Okay, thank you. That's all the testifiers we have on this measure. Members, any questions? Representative Ward.
Dr. Otto, please. Dr. Otto, your
Yes.
amendment, does that suggest that's only for medical marijuana, or is that sort of generic across the board for changing through your amendment?
Well, so the issue here is really the impact of the state authorized use of cannabis upon federal regulation. And so currently, if this amendment were to be added and adopted, this would only apply to the state authorized use of cannabis for medical purposes, but it could certainly apply to future situations if the state decided that it wanted to broaden the authorized authorization to include so-called personal use. My position is the state really shouldn't broaden any more use of cannabis in Hawaii until this federal conflict is resolved. And I believe this amendment is a way for the state to take action on this conflict that it created over 20 years ago when it constitutionally decided that cannabis has medical use in Hawaii.
Thank you, Dr. Otto. Thank you, Chair.
Thank you. Members, any other questions?
Chair.
I'm sorry, who is that?
Chair Lopresti.
Is that Lopresti? Okay, Representative Lopresti.
Thanks. Same gentleman. Question. I'm not sure why But under section 3, the new section 3, the bill's deleting approved cannabis drugs with no more than 0.1% residual tetrahydrocannabinoids from the statute. What role does that play? Is that going to put it in line with the Controlled Substance Act, or?
Representative, did you want me to address this question, or did you want
Yeah.
Administrator Radula?
Well, actually, either one of you, frankly. I'm
Um,
just confused on that issue.
Representative Lopresti, this is Jared Radula, the Administrator of Narcotics.
Hi.
With respect to your question, sir, the federal government has already descheduled Epidiolex, and so what this measure does is harmonize our laws to the same level that the federal government has. And
Okay,
that
so
don't have differing levels of control.
just because it's deleting it there, it's just putting it in line with. Got it. Thank you. Thank you, Chair.
Okay, members, any other questions? If not, we'll move on to HB 1107 relating to computer crime. First up, we have the Office of the Public Defender in opposition.
Aloha, Chair Nakashima and members of the committee, Deputy Public Defender Darcia Forrester, on behalf of the Office of the Public Defender. We'll stand on our written testimony. We have a very specific concern, which we outlined in our written testimony, and I'm available for questions. Thank you.
Thank you. Next up, we have the Department of Education in support.
Thank you, Chair, Vice Chair, members of the committee. This is Brooke Connor, the CIO for the Department of Education. We will stand on our written testimony in support of the intent and some comments. We are, of course, available for any questions you may have.
Okay, thank you. Next up, we have the LGBT caucus of the Democratic Party of Hawaii in support.
Good morning. Good afternoon. Sorry. I'm Michael Galoyu on behalf of the LGBT caucus of the Democratic Party of Hawaii. We want to thank you for hearing this bill. Unfortunately, it's sad that we actually do need this bill, as we've seen bullying leave our school grounds, following our students across many different platforms. And we encourage you to pass this bill as it is. We do need to do it to protect all of our keiki. Thank you, and I'm available for questions. Mahalo.
All right, thank you. And last up, we have an individual submitting late testimony, Mike Kunishima, in support.
Good afternoon, Vice Chair. I'm Captain Michael Kunishima with the Honolulu Police Department. HPD stands by written testimony in support of this bill. Here for any questions if needed. Thank you.
I did not realize that was HPD. Members, any questions? Representative Nakashima. I'm sorry, Nakamura.
I have a question for the DOE.
Yes, Representative.
Connor, I wanted to find out, during this pandemic, how many computers did you lend to students throughout the state?
So we purchased about 52,000 new computers using federal money. Of course, there was an existing population of about 125,000 devices that the schools already owned that were loaned to students. At this point, there's about 2% of the student population that does not have access to a computer of their own.
So if any of those students use their computer to bully, and it was traced back to a DOE computer that was lent, then that computer will have to be taken away. There's under this bill. It would be confiscated.
So it would be my reading of the bill, and I'm not a lawyer, is that it could be subject to seizure as part of this bill. That could be a concern. Certainly the expectation for the department is if a student is doing bullying, that's something the department takes very seriously, as we talk about in the testimony. And we would take disciplinary action against that student consistent with the issue. And certainly if they were using department equipment to do it, we would take issue with that.
The way I read it, though, that this bill says that it shall be forfeited. But I think that's what the public defender brought up in their testimony. But I think they're recommending the word, rather than shall, that there be the word may, so that there's some discretion, should it be like a DOE computer? Would that make more sense?
So I think that makes a certain amount of sense, and I didn't see the public defender's testimony before this hearing. I think certainly if a student was using department equipment, the department wouldn't need this law to curtail access by that student to the department equipment. Where there certainly would be some concern is, does this bill give us the right to seize a parent's computer from a student? Does this bill give another agency the right to seize department equipment if it's being used to conduct harassment? I think those are some of the questions that come up, and perhaps a way to address that might be switching from a shall to may
Thank you.
language.
Thank you, Chair.
Okay, thank you. Members, any other questions?
Chair, I have a question.
Is that Rep. Cressy?
Yep,
Rep. Cressy.
thank you. Dewey, I just wanted to
Yes, sir.
follow up on Rep. Nakamura's questions. I think she's definitely right. Do we have any other, I totally support getting rid of bullies and everything, especially in the cyber environment. But does the DOE, how does the DOE handle bullying now? I mean, do they have such wide-ranging punishments some of these computers, it could be a $150 Acer, or it could be a $2,000 computer for the same offense. You could end up punishing a family $2,000 or $150. You guys stand by that?
So I certainly would not say that if it was mandatory that bullying requires seizure of a computer, because the way that discipline is carried out in the schools today, the principal has latitude for the extent of the disciplinary action taken. So there's 4 different categories of severity, A, B, C, and D in the school disciplinary process. And there are guidelines, but certainly not requirements.
Yeah.
Class
Well,
A is the most
sufficient.
important one and includes felonies. So,
Yeah. But whereas this measure would seem to require the same sort of punishment across the board. And public defender, real quick. Thank you, sir.
Hello.
Ma'am, and my understanding of this bill is that the legislature in recent years has passed a few times getting rid of civil asset forfeiture without being found guilty of a crime. Is your opinion, does this bill continue to expand civil asset forfeiture without having a actual finding of a crime?
Well, I think that we would equate this with civil asset forfeiture, because you're removing property from someone. And then the problem is that there's with civil asset forfeiture, there's a procedure in place, and it's not a criminal proceeding. It's a completely separate proceeding. This would be done, I believe, through the criminal courts. So that's, I believe that would be the difference between the two, but it's the same result. The property is seized and taken.
What if by chance the bill were amended to say something along the lines of repeated use or something like that? Then maybe we jump to taking away the device.
Well, our suggestion was to say may, because that way there is some leverage and some review of the facts and what's the item, what's the value of the item, who's using the item, how many times maybe it was used or not used, the age of the child. I mean, because it says shall, let's say a 12-year-old is using it, but the 14-year-old and the 18-year-old also need that computer for school-related activities. The impact goes beyond just the one child. So we were just concerned about that wide-ranging impact.
Thank you so much. Thank you, Chair.
Okay, thank you. Members, any other questions? If not, we'll move on. To HB 1062 relating to commercial driver's license, we have one testifier, Department of Transportation in support.
Good afternoon, Chair, Vice Chair, members. Lynn Araki Regan on behalf of Department of Transportation. We stand on a written testimony and support. Thank you.
Okay, thank you. Members, any questions? The HB 1246 HD1 relating to fireworks. First up, we have Department of Health with comments.
Good afternoon, Chair, Vice Chair, and committee members. My name is Marianne Rossio from the Department of Health. The department stands on its written testimony providing comments, and we're here if you have any questions. Thank you.
Okay, thank you. Members, any questions? Seeing none, moving on to HB 338 relating to the judiciary. We have no testifiers for this measure. Moving on to HB 1339 relating to impeachment. We have no testifiers for this measure. Exciting agenda. Moving on to HB 334 relating to operating a vehicle under the influence of an intoxicant. First up, we have Department of Transportation in support.
Good afternoon, Chair, Vice Chair, members. Yes, Department of Transportation stands on its written testimony and support and are available to answer any questions you may have. Thank you.
All right, thank you. Next up, we have HPD in support.
Yeah, good afternoon, Chair. I'm Lieutenant James Slater of the Honolulu Police Department's Traffic Division. We stand by our written testimony in support of this bill, available for any questions you folks may have.
Thank you. Next up, we have prosecutors in support.
Good afternoon, Chair, Vice Chair, members of the committee, Deputy Prosecutor Tricia Nakamatsu on behalf of the Honolulu Prosecuting Attorney's Department. We also stand on our written testimony and support, available for questions, if any.
Okay, thank you. And that's all the testifiers we have. Members, any questions? Representative McKelvey.
Just two quick ones. First, DOT. Are you still there? Hey, Lynn.
Yes, we
Quick
have.
question.
Yes, we have staff.
Oh, yeah, sorry. Why does the director of the DOT want to get involved in the all-drill ignition interlock process? I'm just curious. I read the bill, just glanced at it. Like, it just seems kind of odd given all the other compelling duties of DOT and everything else. That I'm just curious as to the background from you guys on the, in supporting the measure. That's all.
Well, safety is our primary concern, and to answer specific questions, we have staff from the Highways Division available to reply to your inquiry. Thank you.
Okay, thank you. And then,
Hi.
Oh, sorry. Hello.
Sorry, this is Karen Kahikino with the DOT. I'm sorry, you were asking in regards to ignition interlock, or just the background on the state lab and our interest in it?
Yeah, that's it. The background, state lab, and your interest in it. That's all.
Well, the Department of Transportation is responsible for the drug recognition expert program. So as the state coordinator for the DRE program, we are interested in the toxicology part of impaired driving. So we support toxicology for confirmations and testing in those impaired driving cases.
Okay, thank you. Thank you, Vice Chair.
Thank you. Any members, any other questions? All right, seeing none, moving on to HB 535 relating to manslaughter. First up, we have the Office of the Public Defender in opposition.
Hi, I apologize. Chair, Vice Chair, Deputy Public Defender Jacqueline Esser on behalf of the Office of the Public Defender. Our office opposes this bill for the reasons outlined in our written testimony, which I'll stand on, and I'll be here for questions if there's any. Thank you for this opportunity.
Okay, thank you. Next up, we have Department of Transportation in support.
Lena Raki-Regan, on behalf of Department of Transportation, we stand on written testimony and support. Thank you.
Okay, thank you. Next up, we have HPD in support.
Good afternoon again, Chair. This is still Lieutenant James Slater of the Honolulu Police Department's Traffic Division. We stand on in support of this bill, and we'll stand on our written testimony. Available if you have any questions.
Okay, thank you. Last, we have Nonohe Botello in support. Not present. Are you sure she had called in telling us that she wanted to? Oh, okay. Okay, not here. Members, any questions? Representative Nakamura.
Is there someone from the prosecuting attorney's office in Honolulu?
Yes, Representative.
I wanted to, I think both you and the public defenders both said that this charge can be done already under existing laws. I was wondering, you also talked about an unintended consequence. Can you elaborate on that?
Well, I think the unintended consequences would be those that have not actually been brought to, that we have not even considered, because typically our philosophy is that if a set of facts can already be charged effectively under one type of statute, then we typically wouldn't recommend adding additional statutes that do the exact same thing. Or in this case, we feel that the existing manslaughter statute, actually, we can do a little bit more in that it can cover drugs in addition to alcohol, and we can cover a wider set of facts beyond just drugs and alcohol, or alcohol impairment.
So narrowing the circumstances under which you can charge for manslaughter could make it harder to charge for other drug offenses, or what?
Well, it certainly could be used in a narrower set of circumstances than what we already have available to us. We do support the intent of the bill, however. When we submitted our testimony, we certainly understand the types of situations that raise these concerns. We do take into account all of the different factors based on a wealth of experience that the deputies in our screening division have in looking at these types of cases. They are going to find the most appropriate application for which offense to charge in any given set of circumstances and facts.
Thank you.
Okay, members, any other questions?
Again, prosecutor's office.
Yes,
Yeah.
Representative.
Got a bill in front of your Zoom here. Real quickly, I guess one of my concerns is that the bill has blanks in it for the days and to establish, I guess, some kind of a policy position. What would your recommendation be if there was to be one on so far as the number of days, or the bill is currently blank?
I'm sorry, Representative, this wasn't our bill, so we don't necessarily have recommendations as to the number of days. We didn't necessarily have specific recommendations on amendments.
Okay, well, maybe
I'm
that's
sorry.
something we can just talk about later then. I mean, I'm just curious.
Absolutely. We'd be happy to talk offline about that.
On what the period would be, time period. Okay, thank you. Thank you, Vice Chair. Appreciate it.
Thank you, Representative.
Members, any other questions?
Chair, Vice Chair.
Yes, Rep. LaPresti.
Thank you. Jackie Esser, please.
Hi, Representative.
Hi. I was curious, is there any other sort of reckless endangerment? Because I think obviously a lot of people support the intent of being able to charge somebody with manslaughter in that kind of situation, but is there any other statute that you're aware of that involves reckless endangerment that automatically brings a manslaughter charge?
That would be the manslaughter charge. The way that the manslaughter statute is written currently, it's when a prosecutor can charge when the facts show that someone recklessly caused death. So that could be someone impaired. It could be a blood alcohol of 0.08 or even less. And so this bill is actually narrowing it. And as Ms. Nakamatsu said, it can be misapplied. It can have effects that will hurt both the prosecutor and the defense. And so as the statute stands right now, it's written so that it can be charges can be brought when there is evidence that someone recklessly caused the death of another.
Thank you. Thank you, Vice Chair.
Thank you, members. Any other questions? Seeing none, we're moving on to HB 1263 relating to ignition interlock devices. First up, we have Office of the Public Defender in opposition.
Thank you, Vice Chair. Good afternoon. My name is James Tabe. I'm with the Public Defender's Office. Currently, those who choose not to drive will opt out of this program. And if they get caught driving without the interlock participating in the program, they do get stiff penalties. They get 3 days jail for the first offense, 30 for the second, and a year for the third. What this measure is going to try to do is it basically will require that you have to be able to afford the interlock device, and you have to afford to have a car, and not just owning a car. Car has to be fully insured and have all the paperwork done. So essentially, and basically the thrust of our written testimony indicates, there are going to be segments of the population that will never, ever be able to get their license back in their lifetime because they don't have a car, or they can't even afford to buy the car. And if they do have money to have a car, the family does, they may not afford the interlock device. Now, understand the interlock device, there's a discount of 50% off. It's still a substantial amount of money. Basically what we're going to have at the end of down the road, we're just going to start arresting people or putting people in jail just for driving, not drinking and driving, just driving. Because I would imagine the majority of the ones that get pulled over for 291E62 are not drinking. They're just driving, and they're gonna rack up the fines, or just are gonna be serving jail time just for driving. Otherwise, we'll stand on our testimony, and I will be available for questions later. Thank you.
Okay, thank you. Next up, we have Department of Transportation in support.
Good afternoon, Chair, Vice Chair, and members. The Department of Transportation stands on our written testimony in support of this bill, and we're available for questions. Thank you.
Thank you. Last up, we have Smart Start LLC in support.
Good afternoon, Chair Nakashima, Vice Chair Matayoshi, and members of the committee. Joanne Hamaji-Oto, Territory Operations Director for Smart Start LLC, Hawaii Corporate Office. I'm offering testimony today in strong support of House Bill 1263 HD1 relating to ignition interlock devices. Currently, the only way to stop a drunk driver from reoffending is to install an interlock on the car to physically separate drinking from driving. HB 1263 HD1 will make interlock user-proof compliance and demonstrate they're able to drive sober before removing the device. They must have a certain period of no violations before removal, known as a compliance-based removal, and it is currently law in 34 states. Interlock compliance-based removal laws are important in teaching sober driving behavior. An indigent program is available for those that qualify to lessen the costs associated with an interlock. The Hawaii Department of Transportation established a program to provide partial financial relief on the interlock charges to participants who qualify. If qualified, the installation and monthly service fees are discounted at 50% off the standard rate. That discounted rate breaks down to the monthly service fee cost of the interlock to participants at $1.48 a day. In 2014, the Traffic Injury Foundation provided assistance to the Department of Transportation to improve the interlock program in Hawaii. This bill is a result of the recommendation to not allow offenders to wait out their revocation period and address the problems of offenders continuing to exit the program without proving sobriety to drive. The report concluded that participation rates in Hawaii's interlock program can be improved by straightening the law. Currently, OVUI offenders merely have the interlock removed when it's time for the end of the program, whether they have proven sobriety to drive or not. One of the biggest challenges facing Hawaii's interlock program is eligible offenders wait out the revocation period and do not install the interlock, many choosing to drive unlicensed and not interlocked. We strongly urge you to pass HB 1263 HD1 as it will help strengthen Hawaii's interlock law, which is critically important to help save lives and keep Hawaii's roads safe. Thank you for the opportunity to provide testimony in support of this important bill.
Thank you. Members, any questions? Rep. McKelvey.
Yeah, I have to apologize there, Chair, Vice Chair. This was the bill I was talking about, 1263. So that's why I think the confusion in prosecutor's office. So again, the same question, it's blanks in the consecutive number of days. I don't know which testifier wants to jump in, but what would be the policy recommendation to establish some, because this is a serious area. And so the number of consecutive days could have a real world impact. So any feedback on that? No?
This is Lynn Araki-Regan from Department of Transportation. As reflected in our written testimony, the Department of Transportation is recommending that the period to comply with this section be 90 days for the first revocation or conviction, 180 days for the second, and 1 year for the third or subsequent violations.
And this is based on other states, the recommendations of those time periods?
That's my understanding. We have staff available from the Highways Division to provide any specific guidance. Leanne, John, would you like to comment? Or Robert? Leanne? I know Leanne is on the phone or is available.
That's okay. I'll just go under your statement that this is what they do in other states. Thank you, Vice Chair.
Thank you.
Thank you. Members, any other questions? Rep. Ward.
Thank you, Chair. For the public defender, please.
Yes, Representative.
As I read your testimony, I got the impression that, hey, it's really expensive to own a car in Hawaii, even though the last time I looked, there's more cars than there are people in Hawaii. What did you mean by people who can't afford to buy a car? And I say that as one who at the East West Center and my friends from Southeast Asia would buy $50, $75 cars and be driving all over the island. Now, obviously that's a humble way, but you state unequivocally this bill is no good because people can't afford to buy cars. So
well,
by that?
Purchasing cars, step one, if you could find a $50 car, but you need to be fully insured. First of all, this is a person that has already picked up a DUI or OVUI conviction. So the insurance rate on that matter would be astronomical for this person. And I know there's a little tongue in cheek in your question there, but it is very expensive to own a car. And for many people, especially after they get an OVUI conviction, can no longer afford to drive that car because of the insurance cost premiums that go up. So there is a financial distance, there is just, you're just going to have to force people to start purchasing a car at this point to install an interlock device. And it
let me rephrase the question. Given what you just said, is it statistically accurate then that there are people who cannot afford to buy a car? Do you have numbers to back up your claim? I'm not tongue in cheek. I'm just saying.
I would imagine
there's a lot of cars out here.
No.
And what about, this is about saving lives.
There's a lot.
Interlock to save lives. It's not just something to feel bad for the poor people. It's trying to save the lives of people who are alive and driving other cars that they may be running into.
There's a lot of people that get arrested for stopped or cited for 291E62 at this point. That's driving during the suspended period. Most of those drivers are not driving with alcohol in their system. And that's what we're going to end up doing is we're just arresting and putting people in jail just for driving. And this is, and think about this, this could potentially be a lifetime revocation. So they'll be serving, they'll be punished for an event that happened many years ago, their OVUI, which hopefully they've learned their lesson, but they just cannot comply with the ignition interlock. It's basically, we don't do it. There's no other crime where we would say let's say we place somebody on probation or they get convicted of a crime. If we would trust that they stay out of jail or they stay out of trouble. This is the only crime that I can think of where we're going to start adding these things for a period of time after their conviction, especially they're not even on probation at this point. So if we can apply the law fairly or equitably, and I know it's clearly driving is a privilege, and I understand that, but it shouldn't just be the privilege for the affluent.
Not to be an iconoclast, but I think you're a little bit outdated in that statement, quite frankly. But thank you very much for your input. Thank you.
Okay.
Members, any other questions? If not, I've got one for the public defender. I want
Yes, Vice Chair.
to build off of what one of your responses to Representative Ward and your testimony in which you state that the affluent offender's license will be restricted to the minimum revocation period, while the indigent person will suffer a lifetime license revocation. I'm having trouble understanding where the lifetime license revocation would be if they do not participate in this ignition interlock system. I didn't see it in the bill. I'm wondering what area of the law you're talking about.
Well, basically, it seems like you cannot get your license back, or it's going to be revoked until you comply with the ignition interlock system.
So your reading of this bill is that it's going to make, if you get arrested for a DUI and you refuse to do the ignition interlock system, you will not be able to recover your license until you do.
Apparently, that's how the bill reads. Yes, that's how we read the bill.
Okay, I do not read it the same way.
Is there a time period where they're going to be able to get their license back without the ignition interlock system?
That was literally my question to you.
No, from what I gather, they go to DMV, they're not going to get their license. They won't be able to get their license because there's an outstanding. It's just like when because the OVI, they also have you got to take your 14-hour class or your class. You won't get your license back until you complete the class, no matter what time period passes. So it's basically we're adding this feature or this requirement to able to get your license back. So at this point, I just can't see individuals receive their license, and especially now when we want to get away from cars in the future, and we want people to, take mass transit, etc. Rent cars.
Another method to recover their license without any sort of class or training or interlock system. I mean, that seems that seems like a bad policy to let people back on the road with no rehabilitation either.
That's what the bill is basically. That's what I see at this point. That's how we read the bill.
Okay. Thank you, Rep. Nakamura.
I have a question for the prosecutor's office. They're not.
Or the prosecutor's office is here. They're just not testifying on this measure.
They're not. Okay, because they have the similar concern that the public defender had, that prohibiting low-income individuals from ever getting that this bill would have the unintended consequence. Thank you.
Is anyone from the prosecutor's office here and able to respond to that?
Yes, Chair. I'm sorry. I didn't know if you wanted me to speak up or if you wanted me to sit out.
Oh, please.
Okay. Yes, it is actually one of those rare instances where we have similar concerns to what the Office of the Public Defender is saying. We actually read the bill the same way. And we would agree that absolutely driving is a privilege, not a right. But as Mr. Tabe indicated, something seems inherently unfair about reserving that privilege only for people who are rich, not rich, but have enough money to afford all these things to be able to get their license back. We do support the bill's intent. We absolutely support stricter policies for OVI offenders, penalties. And we were part of a working group it was 2 years ago now, summer of 2019, that worked intensively statewide with county prosecutors and police to develop a number of bills, which are being also heard by this committee and other committees. I believe the one name for this type of enforcement mechanism is called compliance-based enforcement. And the committee was unfortunately going to take a very close look at there's many different types of compliance-based enforcement that can be done all across the country in various forms. This is not the only way, but there's so much information and there's so many different ways to implement and to see how they interplay with our specific situation here in Hawaii. That was all supposed to be done last summer in 2020. And so unfortunately, because of the global pandemic, we weren't able to continue, but the working group members had all indicated that they wanted to reconvene and work on that component.
Thank you for clarifying the concern.
Yep, thank you. Rep. Kelpie.
Real quickly, I guess prosecutors again, since you got hauled in on this bill. Isn't there an indigent program in Hawaii for people who have that kind of challenges already?
Not currently for ignition interlock.
Not for ignition interlock. Okay. All right. Okay. Thank you.
Okay, thank you. Members, any other questions? If not, we'll move on to HB 459 HD1 relating to commercial driver's license disqualifications for severe forms of trafficking in persons. First up, we've got Department of Transportation in support.
Good afternoon, Chair, Vice Chair, members. Lena Rocky Regan on behalf of the Department of Transportation. We stand on a written testimony in support, and we're available for questions. Thank you.
Okay, thank you. Members, that's all the testifiers we have. Any questions? Right, seeing none, moving on to HB 576 HD2 relating to healthcare. We have quite a few testifiers. First up is DCCA in support.
Thank you, Chair. My name is Leanne Tashima. I'm the Executive Officer for the Board of Nursing. We'll stand on our written testimony in support of this bill. I'm here if you have any questions. Thank you.
Okay, thank you. Next up, we have Hawaii State Commission on the Status of Women in support.
Aloha, Chair, Vice Chairs, members. We will stand on our testimony and emphasize that this is really an urgent COVID-19 response measure. So wanted to make sure that that's the right framing because it has to do with the response to women. Thank you.
Okay, thank you. Next up, we have the Hawaii State Center for Nursing with comments.
Aloha, Chair. This is Laura Reichart, Director of the Hawaii State Center for Nursing. I'd like to stand on our written comments, and we are available for questions. Thank you.
Okay, next up, we have the Hawaii Health and Harm Reduction Center in support. All right, they're not present. Next up, we have the LGBT caucus of the Democratic Party of Hawaii in support.
Good afternoon again. Michael Galoyu Jr. The LGBT caucus stands in strong support of this bill. One of the reasons we do is because barriers for the healthcare for the LGBTQIA plus community are already so great. And when someone needs to seek this legal option, they shouldn't have to leave their local area, their trusted provider, to go find someone that can be able to provide this legal and safe option. So we encourage you to pass this bill, and thank you for hearing it, and available for any questions. Mahalo.
Okay, thank you. Next up, we have Planned Parenthood in support. Lori, are you there? Lori Field.
Good afternoon, Chair and members of the committee. We submitted written testimony in strong support of HB 576 HD2 with housekeeping amendments to ensure that all people in Hawaii have equal access to abortion care, no matter their income or where they live. Please note that we also submitted with our written testimony the names of 336 individuals from across the state who would like their support to be documented. We're also joined today by young people who will share with you just a few of the myriad barriers that stand between people, particularly those on the neighbor islands, and reproductive health care and rights in Hawaii. As it's currently drafted, this bill takes a critical step forward in ensuring equal access to abortion care by stating that advanced practice registered nurses may provide early and clinic abortions. To ensure that the legislature fulfills that intent, we respectfully request housekeeping amendments to remove the restricted language from HRS 45316, provide consistency, and make the effective date upon approval. With a clean effective date and these clarifying amendments, APRNs will be able to confidently and immediately provide this important care. As a healthcare provider, we care deeply about ensuring that our patients receive the care that they need when they need it. And that also goes for our brave and selfless doctors, nurses, and health center staff. And limiting access to abortion care, particularly during a pandemic, endangers the safety of both patients and providers and incurs great costs for all, including the state, as they're forced to travel to and from neighbor islands to receive and provide care. Qualified providers like APRNs can provide early and clinic abortion just as safely and effectively as doctors. And 12 states across the country have eliminated this unnecessary barrier to care. We look forward to Hawaii joining that growing list and helping to keep us all safe by allowing qualified and more widely available APRNs to provide timely, safe, and local care. This bill stands to have a tremendous and immediate impact on the lives of Hawaii upon its passage, and we are so grateful for your leadership, foresight, and compassion in hearing and supporting this important bill. Thank you.
Thank you. Next up, we have ACOG Hawaii section in support.
Aloha, Chair Nakashima, Vice Chair Matayoshi, and committee members. Thank you so much for hearing this important bill. My name is Rennie Soon, and I am chair of the Hawaii section of the American College of Obstetricians and Gynecologists, whose membership includes over 200 of the state's OBGYNs, and we support HB 576. We are specialists in women's healthcare, and as such, aspiration abortion procedures are a routine part of our training. We are the physician specialty who does the vast majority of these procedures. We are the ones who know the ins and outs of this procedure, and as an expert in this procedure, I can assure you that once a physician or an APRN has been trained to do this, it is an incredibly low-risk procedure. APRNs already perform very similar procedures such as endometrial biopsies and insertions of intrauterine devices. They are perfectly capable of providing this care safely, and in our written testimony, we've provided some references. In California, they piloted a program in which APRNs and other advanced practice clinicians performed aspiration abortions, and they looked at 11,000 abortions that were performed during this program, and there was no increased rate of complications in the abortions performed by APRNs as compared with those done by physicians. There was an extremely low rate of complications in both groups. Because of this pilot program, California changed their law to allow APRNs to perform this procedure. Hawaii ACOG represents the physicians who know this procedure. There are very real reasons why we need this bill, and others are testifying to that. We are in the unique position to testify to the safety of this bill, and we urge you to pass HB 576. Mahalo for this opportunity to testify, and I will be available for any questions.
Okay, thank you. Next up, we have ACLU of Hawaii in support.
Good afternoon, Chair, Vice Chair, members of the committee. Mandy Fernandez on behalf of the ACLU of Hawaii. We strongly support this measure and believe that its passage is necessary for Hawaii to comply with the Hawaii state and federal constitutions. The current physician-only restriction is legally suspect for two reasons. First, it raises equal protection problems. The restriction is irrational because it unfairly targets and prevents certain qualified healthcare providers from providing early in-clinic abortion care. There's no justification for such differential treatment, especially when the scientific evidence is clear that APRNs can safely provide this care. Second, it raises constitutional privacy concerns. The restriction imposes a substantial burden on abortion access and does so without furthering a compelling state interest as required by the Constitution. The burdens imposed by the restriction are clear. By limiting who can provide this care, the restriction reduces access. The burdens are also amplified by other factors, including Hawaii's unique geography as an island state, Hawaii's ongoing physician shortage, and the fact that we're in the middle of a devastating pandemic. These burdens also disproportionately harm people who already face systemic barriers to care, including Black, Indigenous, and people of color, low-income people, and people who live in rural areas. As we've noted in our testimony, there was a recent lawsuit that the ACLU filed in Maine challenging a very similar physician-only restriction. Shortly after that lawsuit was filed, Maine passed a law similar to HB 576. Finally, we proposed two amendments. The first is to make the bill effective upon approval, and the second is to make clarifying amendments in Chapter 453 to avoid an inconsistency between the two statutes. We ask that the committee pass HB 576. Thank you.
Thank you. Next up, we have a number of individuals who both in support and opposition. First up, we have Alani Bankal in support.
Aloha, Chair, Vice Chair, and members of the committee. My name is Alani Bankal, and I am here representing myself as a woman of color. My personal and professional passions have led me to advocate for reproductive health care access and equity for all people in Hawaii. And this work has inspired me to influence legislation on an issue that has impacted every single aspect of my life. I come from a long line of strong women, and the majority of them have received abortion care in their lifetime, all who have supported me in getting the care that I need. So I knew from a very young age that without control over my body, I don't have control over my life. And as a woman who wants to embrace every opportunity in my greatest capacity, having affordable access to birth control and having the choice in when to have children has impacted my success in my education, career, and overall well-being. And I'm very privileged to have a supportive family and the means to access the wide range of reproductive healthcare services. And with connecting to hundreds of people across the island, talking story about their experiences, I have found that the majority of women of color, youth, LGBTQ folks, folks with low incomes experience tremendous barriers when it comes to accessing the same care that has impacted my success so greatly, that people's self-determination often lies across an entire ocean. People spend their last penny on a plane ticket, room and board, childcare for an appointment at a clinic on another island just to get the care that they need. And I think people in Hawaii deserve better than that. And no matter the service they choose to get, they should be supported and trusted to do so, and accessing a service that serves their best interest only. And as people who know our bodies better than anyone, I believe that we should have the power to determine our own healthcare. And as an advocate, I cannot fight to have reproductive healthcare be protected in the law without the right for equitable access within the law. That's why I'm very supportive of HB 576, because I know that this bill would at least reduce the geographical and financial barriers that comes with traveling for a service, especially now within a pandemic. Access has been even more limited to across the islands, and the risk of contracting and spreading the virus while having to travel for a service is even higher. So the urgency for HB 576 is even greater than before. So thank you so much for hearing this bill. It is an honor to testify in front of you today. Mahalo.
Okay, thank you. Next up, we have Alan Wieland in support.
Good afternoon, Vice Chair and members of the committee. My name is Alan Weiland, and I'm a retired OBGYN physician now living on Maui. I'm speaking in favor of HB 576. In my written testimony, I addressed what happens when desperate women do not have access to legal or safe abortion. Now I'd like to address current access to abortion services in Hawaii and the safety of practitioners. There are only a few physicians who are willing to provide abortion services, and they are constantly under attack all over this country. I personally was picketed, and the husband of a patient came after me with a gun. Some of my colleagues have received threats to themselves and their families, and I'm sure you're aware of the violence against abortion clinics that have resulted in several physician deaths. It's imperative to retain termination services as a legal and accessible option. Currently, it is not accessible on the neighbor islands or only in a very limited amount. So to provide more accessibility, we must have a larger number of practitioners available to provide the services and in more locations. This should also reduce targeting of specific individuals. HB 576 provides an avenue to do that in a safe and affordable way. Early termination is very safe, as was referred to before, much safer than carrying a pregnancy to term and delivery. Midwives currently do pregnancy care very well, and advanced nurse practitioners can provide terminations just as well. I urge your support for HB 576, and I'm available for questions. Thank you.
Okay, thank you. Next up, we have Bliss Kaneshiro in support.
Hi, thanks for the opportunity to provide testimony. My name is Bliss Kaneshiro. I'm an obstetrician gynecologist and I'm an abortion provider. And part of my job involves training residents and fellows to perform aspiration abortion. So I'm well versed about the safety of this procedure. Before I came back home to Hawaii, I also practiced in Oregon, where advanced practice clinicians provided aspiration abortion care safely for many patients. And so I've seen firsthand how this can expand access for a lot of patients, particularly those living in rural areas. Thank you.
Thank you. Next up, we have Merritt Shapiro in support. Not present. All right, next up we have Margaret Mejia in opposition. Okay, not present. Next up we have Maddie Walsh in support.
Aloha Chair Nakashima, Vice Chair Matayoshi, and members of the committee. Thank you for this opportunity to testify in strong support of House Bill 576. I'm a graduating senior at UH Manoa, a social worker, and a young woman. I can tell you confidently that my access to reproductive health care has allowed me to be where I am today, pursuing my highest educational goals. But right now, residents across Hawaii, especially in our neighbor island communities, don't share that reality. I'm really frustrated to know that people just like me don't have abortion providers on island and are not getting access to their right to an abortion that they are supposedly guaranteed under federal and state law. A right without access is simply meaningless. Being the island state that we are, people are also being forced to travel outer island to receive abortion care simply because of this outdated physician-only restriction. For those who are willing and or even able to do this, they have to jump through tons of hurdles, taking off work, finding childcare, paying for travel, for lodging, all while now possibly exposing themselves to a deadly virus. Passing this bill would place local abortion care providers all throughout the state, thus taking away these barriers, enhancing public health, and like I said earlier, giving people actual access to this right. Thank you so much for this opportunity to testify in support of this really critical piece of legislation. Thank you.
Thank you. Next up, we have Kim Cordery in opposition. Okay, not present. Last up, we have Leah Minton in support.
Sorry, I apologize. I was used to the letting me know. My name is Leah Minton. Thank you, Chair Nakashima and Vice Chair Matayoshi for this opportunity to testify in strong support of HB 576. I am an advanced practice registered nurse. I practice in the state of Hawaii as a certified nurse midwife. And I specialize in seeing people that have difficulty accessing care. I really wanted to speak in addition to my testimony of really reassuring that the state has already acknowledged in many ways that APRNs are competent and safe practitioners. We are independent providers, and we have been practicing in the state for decades with good outcomes and have been under the governance of the Board of Nursing, who sets our administrative rules. I did not truthfully take the time to dig through the history of where this law eventually originated, and I believe that it probably was the best we could get at that time, and that we're really in a place to move forward and update where our laws are. And so as an APRN, I was offered to be trained in aspiration abortion during my midwifery training in graduate school, because some of the states did allow for APRNs to provide that. And I knew that coming back home to Hawaii, that would not be allowed at that time, but it is something that I, as a provider, do look forward to being trained in that in order to really broaden the scope of practice that I have, or excuse me, broaden the scope of services that I offer under the already established scope of practice. And so I just really want to reiterate that the Board of Nursing under administrative rules and under Chapter 457 already do dictate what it is we are allowed to do within our scope of practice. And that includes all procedures. Aspiration abortion is a procedure and is no different than all of the other procedures that they dictate for us. And so, the main thing that we need at this time is to really get Chapter 453 and 457 to come into alignment, which could simply be stating that the state will not interfere with a person's right to access reproductive health, and that really would take care of this issue we're at this time. But if we do need to duplicate, we just need to clarify 453. So thank you.
Thank you. That's the last testifier we have. Members, any questions? right, seeing none, we're moving on to HB 775 relating to naming Kahului Airport Access Road. We have a number of submitted testimony in support, but no one present to testify on this matter. So moving on to HB 785 relating to firearms. We have two testifiers. First is the Office of the Public Defender in opposition.
Hi, good afternoon, Chair Nakashima, Vice Chair Matayoshi, members of the committee. My name is Lee Hayakawa. The Office of the Public Defender respectfully opposes HB number 785. I guess this is the second time in the same hour that the public defender is on the same page as the prosecutor. The prior testimony submitted by the prosecutor indicated that we do appreciate the good intentions of the proposed bill. However, we both believe that the existing laws cover the type of conduct that is proposed to that's proposed in HB 785. And otherwise, I will stand on my testimony and I'm available for questioning. Thank you.
Okay, thank you. And last up, we have Todd Yukutake in opposition.
Aloha, Todd Yukutake. I oppose HB 785. This is a well-intentioned bill, but it needs some amendments to it. Right now, it only exempts the person's dwelling. It should also, or the walls of their home, basically. This bill should also include their private property, place of work, and place of sojourn, especially for visitors or hunters camping out somewhere, things like that. So those have to be exempted, and also ensure that firearms can be used for self-defense, because you never know when a situation will come up. They just pop up out of nowhere. So make sure that no one's convicted of this law because they use their firearm legitimately for self-defense. Mahalo.
Okay, thank you. And that's all the testifiers we have. Members, any questions?
Chair or Vice Chair?
Yep, Rep. Lopresti.
Public Defender, please. Hi, this is interesting. We got three bills with you guys and the prosecutors all kind of opposed to these. What if we did make a provisional change that said it extended to one's property? Or what do you think about Mr. Yukutake's suggestion about sojourning or whatnot?
Right. You know, I'm sorry.
Go ahead. No, that's it. Would that resolve your concern?
Yeah, I was trying to imagine the kind of situations that the authors of this bill had in mind, whether people were leaving their home and under the influence and sort of recklessly waving a loaded firearm around. You know, and I don't know. So if you want to extend it to property, because as it is written, it's once one leaves their dwelling. So I guess their home proper, it comes into play. I'm not sure how to fix it, to be honest with you. I'm not quite certain how to answer your question. You know, the right to possess extends to the place of sojourn, place of work, and of course your home. So, but I'm not sure exactly what kind of scenario the proposed bill was aimed at.
Well, as one of the primary introducers, I have doubts about it too, given that testimony, and maybe we can fix it. Thanks.
Thank you, members. Any other questions? If not, we are moving on to our last bill of the day on the agenda, the numerically left. Did you have a question, Rebecca Kelby? All right, moving on to our last bill on the agenda, HB 888, relating to covered offender registration. First up, testifying, we have the Attorney General's Office in support.
And good afternoon, Chair Nakashima and members of the committee. I'm Deputy Attorney General Amy Murakami, The Department of the Attorney General supports this bill. This bill creates a bright line rule that requires a person who has been designated a sex offender, a covered offender, or other such sex offender designation in another state to register as a covered offender in Hawaii if that person is a resident of Hawaii or maintains a residence in Hawaii or visits Hawaii for 10 days or visits for a total of 30 days in a calendar year. This bill also provides how such a person can terminate that registration. This bill is consistent with the purpose and intent of covered offender registration and is necessary for public safety. We thank you for this opportunity to testify, and I will be available for questions.
Yeah, thank you. Last on the agenda, we've got Honolulu Police Department in support.
Good afternoon, Vice Chair, Chair, and members of the committee. I'm Randall Platt, a captain with the Honolulu Police Department. We stand on our written testimony in support of this bill, and I'll be available for questions. All right. Thank you.
Thank you. Members, any questions? All right, hearing none, recess for decision making.
Okay, members, thank you for your indulgence. Committee on Judiciary and Hawaii Affairs reconvening for decision-making Tuesday, March 2nd, 2021. Members, for House Bill 1032, Chair's recommendation is that technical amendments needed for clarity, consistency, and style be made. And that's it. Members, any questions, comments? Okay. Representative Ward.
In consideration of Dr. Otto's amendment, was that consideration by the chair?
Yeah, the amendment is considered by the chair, but I don't think it's consistent with the intent of the bill. So we're gonna have to. Dr. Otto keeps coming in with amendments to try and insert into different bills, and we're gonna have to we're gonna have to do a vehicle for his bill at some point. Okay. Members, any other questions, comments? Seeing none, Vice Chair, as amended.
Chair's recommendation is to pass HB 1032 with amendments. Chair and Vice Chair vote aye. Representative Ichiyama?
Aye.
Representative Kobayashi?
Aye.
Representative Lopresti?
Aye.
Representative Lowen is excused. Representative McKelvey?
Aye.
Representative Nakamura?
Aye.
Representative Takumi?
Aye.
Representative Todd excused. Representative Tokioka?
Aye.
Representative Ward?
Aye.
All right, Chair, your recommendation is adopted.
Thank you very much. House Bill 1107 related to computer crime. Chair's recommendation is that we insert language to give the court's discretion if the offender is under 18. Members, any questions or comments? Seeing none, Vice Chair as amended.
Chair's recommendation is to pass HB 1107 with amendments noting the previously excused members. Any members voting with reservations? Any members voting no? Chair, your recommendation is adopted.
Okay, thank you.
Sorry, reservations on 1107, if that's not too late.
Representative Lopresti.
Yeah,
Any
thank
other
you.
members
Sorry.
voting with reservations? All right, Chair, your recommendation is adopted.
Okay, thank you very much. House Bill 1062, House Draft 1, related to commercial driver's licenses. Chair recommends technical amendments needed for clarity, consistency, and style. I'll note that bill already contains a defective date. Members, any questions or comments? Seeing none, Vice Chair as amended.
Chair's recommendation is to pass HB 1062 HD1 with amendments noting the previously excused members. Any members voting with reservations? Any members voting no? Chair, your recommendation is adopted.
Thank you very much. House Bill 1246, House Draft 1, related to fireworks. Chair's recommendation is technical amendments needed for clarity, consistency, and style, and we'll note that it is already defective dated. Members, any questions or comments? Seeing none, House as amended. Oh, Representative Ward.
You know, I appreciate the intent of the bill and that it makes the penalties more difficult, et cetera. But, you know, the real issue has been enforcement. HPD hasn't been able to do it. How the Department of Health can do it, I'm not really convinced. We have a lot of vehicle noise, particularly motorcycles in my district, and that has never been able to be lessened or ceased. So how this is going to work will be interesting to watch. This reservation.
Thank you very much. Representative McKelvey.
Thank you, Chair. I understand this is a big problem. You guys have taken illegal fireworks to a whole new level, but in Honolulu, however, I think addressing this through the air pollution control laws, as noted in the testimony, could create some unintended consequences. So because of that, I'll just go WR.
Okay, thank you very much, members. Representative Nakamura.
I think based on the testimony from the Department of Health about the enforceability due to their staffing and funding, lack of resources, I will also be voting WR.
Okay, thank you very much. Members, any other questions, comments? Okay. Seeing none, Vice Chair as amended.
Chair's recommendation is to pass HB 1246 HD1 with amendments noting the reservations of Representatives McKelvey, Nakamura, and Ward, and the previously excused members. Any other members voting with reservations? Any members voting no?
No.
Representative Kobayashi, no. Any other members voting no?
No.
Representative Tokioka, no vote. Any other members voting no? Chair, your recommendation is adopted.
Okay, thank you very much. House Bill 338 related to the judiciary. Chair will note that on page 5, line 7, the word rescue should be recused. Also, technical amendments needed for clarity, consistency, and style. Members, any questions or comments? Seeing none, Vice Chair, as amended.
The Chair's recommendation is to pass HB 338 with amendments noting the previously excused members. Any members voting with reservations? Any members voting no? Chair, your recommendation is adopted.
Thank you very much. House Bill 1339 relating to impeachment. The Chair will note the resounding silence on this particular measure, but I recommend passing out as is. Members, any questions or comments? Okay, if not, Vice Chair, as is.
The Chair's recommendation is to pass HB 1339 as is, noting the previously excused members. Any members voting with reservations? Reservations, Representative Ward. Any other members voting with reservations? Any members voting no?
No.
No vote from Representative Tokioka. Any other members voting no? Chair, your recommendation is adopted.
Okay, thank you very much, members. House Bill 334 related to operating a vehicle under the influence of an intoxicant. The Chair's recommendation is that we delete the appropriations language in section 7 and 8. Adopt the AG's comments under section 183D-10.5 and other technical amendments needed for clarity, consistency, and style. Members, any questions or comments? Seeing none, Vice Chair with amendments.
Chair's recommendation is to pass HB 334 with amendments, noting the previously excused members. Any members voting with reservations? Any members voting no? Chair, your recommendation is adopted.
Thank you very much. House Bill 535 relating to manslaughter. Chair does have concerns about increasing increasing penalties for existing violations, and so the Chair's recommendation is that we defer this indefinitely. House Bill 1263, House Draft 1, related to ignition interlock devices. Prosecutors have provided the Chair with a note indicating that they probably made some misstatements in fact regarding the interlock indigent fund, and so they've asked if we will defer this one legislative day. So we will move this. We'll do decision making on this tomorrow, Wednesday at 2 o'clock in this room. House Bill 459. House Draft 1 related to commercial driver's license disqualifications for severe form of trafficking in persons. The recommendation is that we utilize the severe form of trafficking in persons to mirror federal law as follows. Severe form of trafficking in persons has the same meaning as provided in Title 22 United States Code, Section 7102. The bill does also contain a defective date. Members, any questions or comments? Seeing none, Vice Chair with amendments.
Chair's recommendation is to pass HB 459 HD1 as amended, noting the previously excused members. Any members voting with reservations? Any members voting no? Chair, your recommendation is adopted.
Okay, House Bill 576, House Draft 2, related to healthcare. Chair's recommendation is that we defer this one day, and decision making will be on Wednesday at 2 o'clock in this room. House Bill 775 related to renaming Kahului Airport Access Road. Chair's recommendation is that we move this out as is. Or is there any questions or comments? Seeing none, Vice Chair, as is.
Chair's recommendation is to pass HB 775 as is, noting the previously excused members. Any members voting with reservations? Any members voting no? Chair, your recommendation is adopted.
Okay, House Bill 785 related to firearms. Chair has shares concerns about this particular measure, and will defer this measure indefinitely. House Bill 888 related to covered offender registration. Chair's recommendations, technical amendments needed for clarity, consistency, and style. And that's it, members. Any questions or comments? Seeing none, Vice Chair.
Chair's recommendation is to pass HB 888 with amendments, noting the previously excused members. Any members voting with reservations? Any members voting no? Chair, your recommendation is adopted.
Okay, thank you very much. Now, members, moving on to bills heard on Friday. House Bill 1105, House Draft 1, related to the University of Hawaii Board of Regents Candidate Advisory Council. Chair will note that this bill already contains a defective effective date and recommends moving it out as is. Members, any questions or comments? Seeing none, Vice Chair, as is.
Chair's recommendation is to pass HB 1105 HD1 as is, noting the previously excused members. Any members voting with reservations? Any members voting no? Chair, your recommendation is adopted.
Thank you very much. House Bill 174 related to eyewitness identifications. Chair will note that in 1991, 30 years ago, previous judiciary chair was faced with a similar bill incorrectly titled pubic officials and made this and similarly ruled the bill out of order and deferred the measure. So we will defer this bill and rule it out of order and defer the bill.
Again.
The pubic official bill was to do away with the state law on resigning to run. It's a Frank Fossey bill. House Bill 175 related to sex trafficking. Chair recommends technical amendments needed for clarity, consistency, and style. Members, any questions or comments? Vice Chair, as amended.
Chair's recommendation is to pass HB 175 with amendments, noting the previously excused members. Any members voting with reservations? Any members voting no? Chair, your recommendation is adopted.
Okay. House Bill 150 related to felonies. Chair is concerned that Class 3C felony would be applied to basically any kind of mechanical hijinks, and finds that may be a little bit too high a sentence, and so recommends that we defer this measure. On House Bill 458 related to driver's licenses. Chair will note that on page 2, line 7, the word issuance should not be stricken. And other technical amendments needed for clarity, consistency, and style. Also to the effect date this to July 1st, 2021. Also adding the DOT amendments to this measure. Members, any questions or comments? Seeing none, Vice Chair, as amended.
Chair's recommendation is to pass HB 458 with amendments noting the previously excused members. Any members voting with reservations? Any members voting no? Chair, your recommendation is adopted.
Thank you very much. And finally, House Bill 1194 related to the statewide traffic code. Members, the Department of Highways did not like this amendment and suggest that perhaps in this particular instance, signage along a particular highway may be better than a statewide law, so we will defer this measure. Okay. House Bill 1010 relating to voting reports. We would like to pass this with an amendment that provides that medical information may be redacted from the report. Members, any questions or comments? Seeing none, Vice Chair, as amended.
Chair's recommendation is to pass HB 1010 with amendments noting the previously excused members. Any members voting with reservations? Any members voting no? Chair, your recommendation is adopted.
And finally, House Bill 1253, House Draft 2 relating to employment practices. Chair's recommendation is technical amendments needed for clarity, consistency, and style. I will note that the bill already contains a defective effective date, and I would like to amend the bill also to exclude situations where employee consents or applications are required as part of the employment requirement. Members, any questions or comments?
Chair, could you repeat that again?
In situations where an employee consents to having an application put onto their phone, or a situation where the employment requires the application be put on their phone for work purposes.
And that's included or excluded?
That's excluding those two situations.
Excluding those.
Okay. Members, any other questions or comments? Seeing none, as amended, Vice Chair.
Chair's recommendation is to pass HB 1253 HD2 with amendments noting the previously excused members. Any members voting with reservations? Any members voting no? Chair, your recommendation is adopted.
Thank you very much, members. We are adjourned.